Thank you all so much for being with us at this hour. I'm Kate Baldwin. Inside Politics starts right now.
This is CNN Breaking News.
Hello and welcome to Inside Politics. I'm Abby Phillip. John King is off. Thank you for joining us on a significant news day. Any moment now, we expect the Justice Department to submit its redacted version of the Mar-A-Lago affidavit used to justify the search of Donald Trump's Florida home. We're going to get straight to CNN's Jessica Schneider. Jessica, while we are waiting, what can we expect to learn when we finally see this document?
Well, we'll find out just how much the Department of Justice was successful in keeping blocked from the public and what the judge and the Department of Justice is allowing the public to see here. Now, in just the past few minutes, we've actually been seeing a lot of activity on the court's docket. Most of it's been under seal, but this indicates that something should be coming very soon. You know, we're just about 1 minute from noon. The thing is, a lot of people are checking the court docket right now all across the country, all over the world, and that might actually lead to somewhat of a delay in downloading this information. So what we do know from the Department of Justice, what they previously said at a court hearing, this is a lengthy document. It has many, many details about multiple witnesses that they've spoken with, their investigative techniques, sources, and methods. However, it has been quite clear from the judge in this case that that information will in fact be blacked out. It will be redacted. The judge issued a 2-page order yesterday basically saying he agrees with the Department of Justice that there is just too much at stake to release a lot of this information into the public sphere. He said that in fact the information about witnesses, grand jury, uncharged parties, those people who may be targets of the investigation who have not yet been charged, all of that information will not be available because, of course, this is the affidavit that laid out the probable cause for that search warrant at Mar-A-Lago that was executed on August 8th. So this is all the information that has been laid out to the judge by the Department of Justice as to why he should have signed off and did sign off on that search warrant. So the Department of Justice has consistently said, Judge, if too much of this information is put out there, it will derail our ongoing criminal investigation. However, you know, the judge had pushed back on that, saying, Department of Justice, I want you to try to see how much you can reveal. And it seems that what we got yesterday, the judge seems satisfied with what the DOJ had put forward. So maybe we will actually get a bit more than we had expected here. It could be a lot of procedural details, but it could still give us more insight into what led to the approval for that search warrant and what the underlying basis for this criminal investigation is. So, Abby, we've just hit noon. We're expecting more activity on the court's docket very shortly, and we'll keep checking it and get back to you as soon as something is filed.
Jessica, stand by. We will get back right with you as soon as you have that document. And joining me now around the table is former federal prosecutor Elliot Williams and CNN legal and national security analyst Carrie Cordero. So while everybody is hitting refresh on Pacer right now, we have a moment where the judge in this case has said, government, I agree with your decision to redact certain elements of it, but yet he still sees fit to release this document. So, Elliot, what does that tell you?
Well, what does it tell you? Look, it's important to take a step back and just think of what sort of the law governing all of this is, right? In criminal proceedings, documents are presumed, proceedings are presumed to be open, right? That's put in the Constitution. Things should be open. We have an open access to the criminal justice system. Investigative documents, the Justice Department often does not make public, and the law allows that to happen. This judge is allowing some aspects of this investigative document to be released to the public because there's good cause to do that, right? And what he has done is gone through and given the Justice Department an opportunity to black out things that might jeopardize future investigations or the one they're working on. That's what we're going to see today. The devil's in the details, literally, of what the Justice Department is going to be able to black out and still have this document be somewhat useful.
There are some who question that call, right, that it is even in the public interest. Here's a conservative attorney and commentator at the National Review, Andrew McCarthy, writing that this is a criminal investigation. We are not talking about a classified FISA warrant that we were never going to see. Since we're probably going to find out soon enough what's in this affidavit, there is no great public need to find out now when the downside would be to undermine the government's investigation. Carrie, I know you are sensitive to those concerns as well. Do you think that is true, or is the judge right to release something?
Yeah, well, I think in one part the question is, what's the rush here? why this really, really tight deadline that the judge imposed on the Justice Department to have to really carefully go through this lengthy affidavit and determine in really quick time what they can afford to release that hopefully won't disrupt their investigation. So one question I have is, why has the judge pushed the timeline on this so far? And then the next piece is the challenge here is, can the Justice Department produce a document according to the judge's order that's going to be meaningful? In my view, the worst outcome is going to be a document that contains a little bit of information that's subject to misinterpretation, that then opens the Justice Department up to, oh, they selectively redacted the information, and really the public doesn't even have that much more information.
But wouldn't you think that if the judge has looked at the redactions, said, I accept those redactions, and still releases it, wouldn't you think that that means he believes that it is substantive enough that it would provide some clarity to the public?
Again, the standard is it in the public interest to release the document? And that's a fuzzy standard. And the judge has decided that there's some use to the document. But once you get beyond names and addresses of individuals, there's other information that might be attached to somebody's name that can still tip off who they are. Abby Phillip talked to two individuals on Friday, August, I think it's I don't even know what day it is anymore, but the 26th or whatever, right? And that could give away both of our identities right here. Think about that over the course of a 25 or 50-page document, the number of pieces of information that you're going to have to redact out, and that applies to places, objects, pieces of individual evidence, individuals who haven't been charged with crimes or might be charged with crimes in the future, might be witnesses. So what you may end up with is literally a document of pages and pages and pages of black boxes. And it's hard to see how that could be in the public interest, but we'll see. I don't know.
The elephant in the room, though, is what you just said, the charges. What is the likelihood that there are charges forthcoming as it relates to this document? Because, yeah, the affidavit might be unsealed if there are charges, but we can't be sure that there would be.
Well, the affidavit is, the judge has ordered that it's going to be unsealed, and nobody has been charged with anything yet. And so that in itself is a risk, because if too much information is revealed through the publication of some of the affidavit, then that actually can potentially expose people who might not be charged with crimes. There's other people who may have been involved in handling the information that ended up at Mar-A-Lago who may or may not be charged with crimes eventually. And if information about them is put into the public, that actually is an invasion of their privacy. So there's a lot of really delicate aspects to the Justice Department conducting an investigation and information about that investigation coming out too prematurely.
And I think what folks don't understand is that this isn't just about the President of the United States being potentially the target of a crime. There could be other people being investigated for crimes, but the search warrant just happened to happen at Mar-A-Lago. If Carrie and I are engaged in a drug trafficking conspiracy, and I'm the head, the kingpin, but she's got the suitcase of crystal meth at her house, they can search her house but still charge me with a crime. The mere fact that her property was the one searched doesn't mean that she's the only person who might. And so, there could be many, many people here whose privacy rights and criminal justice rights are at stake.
It's always important in moments like this to remind people there's a lot that we do not know.
Yes.
And that is incredibly important even when we get this document, because there's still going to be a lot that we don't know. One piece of information that we've received in some of the reporting that my colleagues have done is about what is going on in Trump world inside the former president's head. Our colleagues report that one source close to Trump told CNN that Trump has posed the question about a potential indictment to members of his inner circle. Another advisor acknowledged that while Trump has certainly been in legal peril before, this seems different and potentially more dangerous, particularly because the former president no longer has the legal protections afforded to the executive orders or office. So two separate issues here. There's the Trump circle, and then there's Trump himself. But there's clearly some concern here that the investigation is centering on the former president or people close to him.
Well, allegations of mishandling classified information are violations of significant federal crimes. The mishandling of classified information falls under the espionage statutes. That's where in criminal law it resides. It's a really serious federal crime. Now, I can think of case examples where former senior intelligence government officials were charged with mishandling classified information, taking information back to their home, but those only ended up as misdemeanors. In one case I can think of was a pardon eventually, and one case was someone who ended up pleading guilty, but those people did not face jail time. That's different than other cases I can think of where former government officials who had access to classified information gave that information to somebody else, gave it to a member of the media, gave it to a foreign government. Those cases are cases where people end up charged with really serious federal crimes and they end up going to jail. And the difference here and the problem with potentially releasing this affidavit is that the FBI's investigation was ongoing. And the piece that I imagine they are still trying to investigate is whether these documents ended up in other hands other than the former president. And that can make the huge difference in terms of the potential criminal exposure.
And on top of that, picking up on the former president versus current president point, there's a big, big difference between charging a former president who is a private citizen with a crime and charging a sitting president with a crime. This came up many times over the course of the last 2 or 3 years. The presidency is the one role in United States government that is, for lack of a better term, unitary. Nobody else fills the role. It's not like the Chief Justice where somebody else can step in and take the role. There are simply functions that the president has. If you charge that person with a crime, you could create a constitutional crisis. And that was one of the things that sort of tied up the Justice Department and Robert Mueller.
But that's not the case.
That's not the case
in this
here,
particular
citizen, yeah.
situation. Carrie and Elliot, stand by for us. We're going to go to Evan Perez, our senior justice correspondent, and Caitlin Polantz, our senior crime and justice reporter. Evan, I know that the Justice Department has met their noon deadline to produce this document. What are we waiting for at this moment?
Well, we're waiting for the creaky system of the court document system to actually give us the document that the Justice Department filed. Jokingly last night I said, knowing these lawyers at the Justice Department, and especially the ones at the National Security Division who are handling this, I jokingly said that they were going to wait till 11:59, 59:50. That appears is what has happened here. And so now we're waiting to see. Look, one of the things that I just listening to your conversation, I think, in reading the order from the judge ordering that this be released, he said that, he viewed what the government had submitted as meeting its burden of showing that the proposed redactions are narrowly tailored to serve the government's legitimate interests. And that's what I think we're going to see. We're going to see a document that is narrowly tailored in the view of this judge, in the view of the Justice Department. And so we're probably going to see a lot more perhaps than they normally would on redacted types of documents. Obviously, we almost never see a document like this at this stage in an investigation. But obviously, because of the unprecedented nature of what has happened, the search of a former president's home, the finding that there are perhaps up to hundreds of pages of classified documents, some of them at the highest level of classifications, found in an unsecure place, which is the beach house of the former president, has brought us to this point. Now we're all sitting here refreshing Pacer, and that might be adding to the problem of us trying to actually get this document. Hopefully we'll see that soon, Abby.
Hopefully we will see it soon. I mean, everyone probably in the United States and around the world is hitting that refresh button. And Caitlin, you have been following the docket back and forth on this for quite some time. What do you make of what the judge has said over the last week, first in his decision to say, I believe that some of this needs to be released, and now to do it, frankly, so quickly after the Justice Department submitted to him those redactions?
Abby, I actually was just reviewing what the judge has said, and one of the things that really jumped out was when he first decided that there was an interest here to have this transparency, to have a level of negotiation with the Justice Department of what could be unsealed. He wrote that he wanted to do this because he wanted to promote public understanding of historically significant events. Historically significant events, plural. And that really is something we should be remembering right now as we're waiting to see what is in this affidavit. There are so many pieces here that we have never really been down this road before, at least in the modern era of the presidency, especially post-Nixon. The way these documents have been handled, that is historically significant, apparently from what we know so far, for a president to leave office, take with him without the help or apparently with the blessing of the National Archives at that point in time. The fact that there's a criminal investigation into a former president or those around him, we don't know if it's him exactly, but a federal investigation into the handling of federal records of national defense information related to a former president, and then also the search of the former president's home, Mar-A-Lago. We have never really seen anything like that before. And then finally, the last thing that's historically significant about this is the transparency that's happening here. We never see this related to affidavits whenever there's an ongoing investigation. This is the sort of thing that the Justice Department holds the closest to their chest, not even after an indictment, but once someone is convicted. They usually don't even let you see this until a case is totally wrapped up. So we really are living in an unprecedented time, awaiting to see what is in this document.
A very important point. I do want to emphasize that this is an incredibly significant and historic day because of the nature of what we are talking about. And now everyone stand by.
Abby, I think we have
the Department of, that's right, Evan, the Department of Justice's legal brief has been explaining the redactions, has been unsealed. This is not the affidavit itself, but rather the memo outlining the redactions. We're going to go to Jessica Schneider, who has the details for us. Jessica.
Yeah, Abby, so what we're getting right now is not actually the redacted affidavit, but rather the memorandum of law the DOJ also submitted yesterday explaining the reasoning behind the need to redact a lot of this information. So it's really two different documents at this point. One of the documents is a lengthy legal explainer. The other one's actually pretty interesting. It goes through the exact paragraphs of this affidavit. The document I'm looking at shows about 78 paragraphs of the affidavit in all, and then lists all the reasons why information should be redacted. However, all of those explanations are in fact redacted. Then you go to the memorandum of law that has been released, and it tells the judge exactly why certain elements need to be kept out of public view. And the very first thing it talks about is the identity of these witnesses. This is something that the government has talked about during that court hearing, talking about really the danger to these witnesses that have provided information throughout this criminal investigation, the danger that they could face if any information, any identifying details are released to the public. The DOJ saying this information needs to be sealed to ensure their safety. Information in this affidavit, they say, could be used to identify many, if not all, of these witnesses. And as we've stressed before, this shows us that the DOJ has been talking to many witnesses throughout this investigation, not just one here. I mean, it says specifically, if witnesses' identities are exposed, they could be subjected to harms including retaliation, intimidation, or harassment, even threats to their physical safety. So the DOJ making clear here how dangerous this would be. The memorandum of law goes on not only to talk about witnesses, but to talk about how they have to keep the information about the roadmap to the investigation under wraps. Because, Abby, as we've repeatedly said, this is an investigation that's ongoing. It is very unprecedented to unseal an affidavit before charges have been filed, and that's exactly what the judge is doing in this case. So the DOJ laying out exactly why much of this affidavit needs to be redacted, remain sealed. So still waiting on the affidavit itself, but getting a little bit more information from DOJ about why they need these necessary redactions. So stay tuned for more.
Jessica, we'll be back with you as soon as you have more. Let's come back to the table with Elliot and Carrie. So, Carrie, what do you make of the fact that this explanation of the redactions was actually released? I'm not sure that was expected, but perhaps it was.
So the memorandum of law is laying out some of the things that we were describing before in terms of it's really the Justice Department explaining why most of the affidavit cannot be released to the public. And they're looking through the memorandum of law very quickly. It looks like there's 5 reasons, as Jessica was describing: witnesses, that it would provide the roadmap to the investigation, grand jury information, importantly, the safety of law enforcement officers who have been involved in this investigation, and then something we were describing earlier, which is the privacy interests of individuals who might be referenced in the affidavit but not eventually charged. So this memorandum of law is really laying out the reasons why, in a normal course of business, the Justice Department would not want this information out, and why it really respects people's constitutional and privacy rights to not have all of this information spilled out into the public. Another notable thing that I saw quickly in the memorandum of law is the Justice Department argues in this document that the facts of this case are particularly compelling. And so there are circumstances in this investigation, most likely because it involves national security, most likely because there have been threats to individuals in law enforcement who have been involved in this investigation, that there are even heightened reasons in this case, maybe as opposed to a regular case, why so much of this investigative information would be premature to be re-released.
And as a reminder to our viewers, the reason we are having this discussion is actually because news organizations, including CNN, have asked for this affidavit to be released. The government opposed it. They proposed their redactions. But the Trump side, even while publicly they've been saying in the media, we want the warrant, we want the affidavit, we want the witness list, in court, they have made no such argument.
Which is a little bit perplexing because really this is not a political proceeding in a courtroom. There's time for politics, right, in America, but that doesn't win in court. And if they wish to take a position with respect to any of these documents being released, they ought to have filed so in court. This is a really interesting document because what it does is sort of just state things that you kind of could Google. It's the law governing why the Justice Department or why our system does not allow grand jury materials to be released. It states a couple cases and then says, for example, and then it's a page of black marks. And that's pretty much on everything. There are privacy interests at stake in this case. Then it lays out the law on privacy and then says, for example, and then has redactions. And so really it's an important document because it's not just the opinion of the Justice Department. These are cases that are either the Supreme Court or other cases in America that lay out what governs documents like this, but you're not really finding out anything in particular. I mean, they do say the public is aware that there was a search at Mar-A-Lago, right, and then it's black after that.
Well, everyone stand by for just a second. Let's go to Caitlin Collins, our chief White House correspondent. Caitlin, the Trump world, I am sure, is also waiting to see what is in this affidavit. What are you hearing about what's going on over there?
Yeah, I think it's important to remind people that Trump and his legal team have not gotten a look at this document either. The government is not required to show them the affidavit, which was, of course, behind the search of Mar-A-Lago. And though, as you were noting, Abby, he has called publicly for it to be released, and so have some of his attorneys on cable news, on social media, they haven't actually argued for that in court. And the government actually notes that here in this filing, saying they recognize that the former president has spoken publicly about this investigation and has said in a public statement he wishes for the affidavit to be disclosed in its entirety, although the court has noted that neither the former president nor anyone else purporting to be the owner of the premises has filed a pleading taking a position on this. So noting they are talking about it publicly, they have not actually taken a position in a courtroom on unsealing the affidavit, and they said they would like to see the entire thing released. And I think, Abby, as we wait for the actual affidavit and we look through the reasons for why they wanted these certain parts of this to remain blacked out, to remain not seeable to the public, they also say the government has well-founded concerns that steps may be taken to frustrate or otherwise interfere with this investigation if the facts were released too prematurely. So noting, really the concerns that they have here about if they reveal too much, it affecting the outcome of this investigation. Trump and his legal team are watching closely to see what this says. He has been huddling with his attorneys this week, and so they will be watching and refreshing just like everyone else, Abby.
Yeah, and that's a very significant piece of the filing that you just read there about their concerns that disclosures could end up disrupting their ongoing investigation. But Caitlin, I want to ask you about President Biden. He was asked about this issue of whether national security has been or is being compromised. What did he say?
This has been a major question for the White House because for obvious reasons, they have not wanted to weigh in on this investigation. They did not know about the search, they say, until it actually was happening at Mar-A-Lago. They found out through public reporting like the rest of us, something that President Biden reminded reporters of this week. But a big question has been their concerns about whether or not any kind of U.S. national security secrets were compromised, potentially sources and methods maybe, by the fact that these documents were at Mar-a-Lago. And clearly we saw a grave concern that the authorities had about this as they were discussing the need to get these documents back, to be able to go through these documents and basically, Abby, do a damage assessment of what was taken to Mar-a-Lago and kind of left in the storage room. When President Biden, though, was just asked a few moments ago if he thought national security had potentially been compromised by these documents being kept there, he paused for a moment and he said that they are going to let that determination be made by the Justice Department. He said, quote, "We'll see what happens."
Caitlin, thank you. We'll be back with you throughout this hour. And we're going to go now to Evan Perez. Evan, we're also learning about a key reason that the Justice Department tried to keep items from the affidavit secret, as we've been discussing, a concern about threats to witnesses in this case.
Right. I mean, look, this memorandum of law actually talks about, in this 13 pages, it talks about that we've already seen threats made to the FBI agents who were involved in this search. And I'll read you just a part of it. It says FBI agents who have been publicly identified in connection with this investigation have received repeated threats of violence from members of the public. Exposure of witnesses' identities would likely erode their trust in the government's investigation, and it would almost certainly chill other potential witnesses from coming forward in this investigation and others. And let's just pause for a minute and talk about and think about this. We're talking about an investigation that has to do with the former president of the United States. And the Justice Department is, under this, in this filing, is saying that as a result of this, because of the actions taken by members of law enforcement, authorized by a federal judge down there in the Southern District of Florida, there have now been threats, which sort of gets to what we've been living with, frankly, over the last 5 years or so, which with the idea that the former president, with some of his public statements, the statements of some of his allies, can trigger this deluge that goes at whoever he believes is wronging him. And in this case, we're talking about federal law enforcement officers. And of course, for the Justice Department, the concern here is that they're trying to do an investigation and they need to be able to get the trust of witnesses. And according to this, witnesses is very important, because it tells us that it's not just one person who has given information to the FBI, to prosecutors, about what they saw at Mar-A-Lago and what gave them the belief that there was more classified documents to be retrieved there. So we're talking about multiple people, multiple witnesses that the Justice Department says. I'll read you just another part of it. It says, if witnesses' identities are exposed, they could be subjected to harms, including retaliation, intimidation, or harassment, or even threats to their physical safety. It's an extraordinary choice of words to be talking about when you're talking about an investigation that has to do with the former president of the United States.
It is extraordinary, but not hypothetical at all. No. We have seen those threats in real life carried out over the last couple of weeks. So it's very significant. Evan, stand by for us. We're going to go now to Caitlin Polantz. Caitlin, you've got some more information about what else is in the documents that we have so far.
Right, so we're still just looking at this reasoning for why the Justice Department wants to keep things very protected here as this ongoing investigation goes. And to what Evan was saying about these threats, the way that this is being thought about, at least by the Justice Department and the judges agreeing, is that there are two sides of the possibility of risk for witnesses and law enforcement agents. There is the risk in the public sphere, right? There's a public tenor of anger of people that have really threatened, as the Justice Department is confirming here, people that are involved in this investigation, FBI agents in particular. But then there's the private sphere, the sphere of this investigation that is not a hypothetical threat, that it is a real investigation into obstruction of justice. And one of the things, when you look at this legal brief that the Justice Department is writing and saying why they need all these reasons to protect witnesses and to protect law enforcement officers, they say that information regarding investigative avenues and techniques are included in this filing that could provide a roadmap for potential ways to obstruct this investigation. And when we were in court previously last week watching this proceeding play out, it was made very clear by the judge that these are not just hypothetical threats of obstruction, that there is probable cause to believe that there could be obstruction, intimidation, some sort of tampering happening behind the scenes in this case. Abby?
And it's notable also the language. Caitlin, as you know, every single word of these documents matters. The government writes that there are a significant number of civilian witnesses in this case. That struck out to me. Caitlin, stand by. We're going to go back to Evan Perez. Evan, what are you learning?
Well, Abby, we now have the document. It's roughly 38 pages that we're looking at, you know, it looks like from what the judge said yesterday, this is exactly what the Justice Department did. We're talking about significant portions of this document are not redacted, and you know, we're talking, you know, again, just from my eyeballing of it, it's probably roughly half of it is actually visible to us from, you know, from these pages. And, you know, it goes through, from the beginning of it, it goes through the timeline of the Justice Department getting involved in this, which is back in, essentially in February, when the FBI receives a referral from the National Archives that there are these boxes, these 15 boxes that have been retrieved from Mar-A-Lago, and that they contain significant amount of classified information. And significantly, it says here, you know, there's a lot that is redacted, but it says there is further probable cause to believe that additional documents that contain classified national defense information or that are presidential records subject to record retention requirements currently remain at the premises. And this is significant. There is also probable cause to believe that evidence of obstruction will be found at the premises. Again, this is why the FBI believed that they had to take this extraordinary step, which was that they believed they could find evidence of obstruction, not just the storage of classified information in an unsecure way, but just the idea that there might be obstruction, which we don't know a lot more about what that is, but it really says that they were concerned perhaps about the destruction of evidence or other methods to try to evade what the FBI was trying to investigate.
Evan, let's go to Jessica Schneider right now as well, bringing her into the conversation. Jessica, you've been going through this document as it's just come out moments ago. What are you learning from your initial read of it?
Well, Evan touched on a lot of it as well. I mean, you know, we're getting a lot of information here, you know, just to show viewers at home what this is like. I mean, the first few pages of this actually do have a lot of information. However, it's the back half that's significantly blacked out. We're going through that, and at the end of this, we're also seeing a letter that was sent from counsel for the former president, Evan Corcoran, who's been significantly involved in this entire investigation and the back and forth with the National Archives, as well as Jay Bratt. He's the chief of the Counterintelligence and Export Control Services at DOJ. He's been at the forefront of this investigation. And it talks about, in this May 25th letter, I'll just read a little bit for you. I mean, it says, "Dear Jay, public trust in the government is low, and at such times adherence to the rules and longstanding policies is essential." And it talks about Trump's political power in the Republican Party. And it's really pushing back against the DOJ and this entire investigation. You know, we know from this affidavit that the FBI investigation began in February of 2022. This letter to Jay Bratt happening in May 2022, just a few months later, and really pushing back. There are bullet points here. I'll read the few bullet points. It says the president has the absolute authority to declassify documents. This is an argument that Trump's team has repeatedly made, that he had this standing order to declassify documents that has been disputed in many realms. In fact, our Jamie Gangel talking to more than a dozen former Trump officials disputing that there could be a, quote, standing order to declassify. President Trump's attorney saying that any presidential actions involving classified documents are not subject to criminal sanction. That they were making that argument, but obviously this criminal investigation continued nonetheless. It's claiming that DOJ is under political influence here. Again, that's another argument that we've seen Trump's team repeatedly make, even though the Attorney General has said that there would not be any political influence, that they would follow the facts and the law. And then it says DOJ must be candid with judges and present exculpatory evidence. So this was Trump team pushing back on the DOJ in May 2022, several months before that search warrant was executed at Mar-A-Lago. So we're still going through this document, but there's a lot to be gleaned here, in particular how Trump's team was reacting to this continued investigation, their pushback just before, several months before the search warrant was actually executed. Abby?
Jessica, that's extraordinary information, what you just read for us. But let's go back to Caitlin Polantz, who has more about what is in this document that explains how this investigation came to be in the first place. Caitlin.
Well, Abby, there's quite a bit unsealed at the beginning that refers to how this came about, right? We have known a little bit that the National Archives for a year, essentially, after Trump left office, kept asking them, we need to get these boxes back. We know you have them. You know you have them. We need to get 24 boxes out of your presence and back into the hands of the federal government. And then this year, January, is when 15 boxes were finally transferred. This affidavit says that at the beginning of February, that is when this became a criminal investigation. And the reason it became a criminal investigation was what the National Archives found within those boxes. So I want to read a little bit from this itself, because it's actually much more than we knew before. So the National Archives referred this to the Justice Department, and they also were noting that in their preliminary review, these boxes, these 15 boxes that Trump had for a year, contained newspapers, magazines, printed news articles, photos, miscellaneous printouts, notes, presidential correspondence, personal and post-presidential records, and quote unquote, a lot of classified records. And then the Justice Department writes, of most significant concern was that highly classified records were unfolded, intermixed with other records, and otherwise improperly identified. And we know from the reporting so far on this that the records that were contained in some of those boxes were so highly sensitive that they really did need to be cataloged appropriately, that they needed to be kept in specific areas, that it would be documented who would even have access or looking at them at any given time. So that really is how this started. The National Archives was involved. The National Archives Inspector General was involved, and they got the Justice Department involved pretty quickly several months ago this year.
The substance of what was found in Mar-A-Lago, a lot of classified documents, to quote this affidavit, but also how it was stored, intermixed with other documents that were not classified, that were personal in nature. That's the key part there. Caitlin, stand by for us for just a moment. Let's go to Evan. Evan, on page 17 of the affidavit, there is a paragraph that you say jumped out to you.
Yeah, so on page 17, paragraph 47, it describes that the FBI agents who reviewed the initial 15 boxes of documents that were retrieved and taken back to the National Archives in January of this year. And it describes that a preliminary look at the documents found 184 unique documents bearing classification markings. That's a lot of documents. These are documents that, according to the FBI, would have ranged from everything from confidential to top secret. It talks about 67 documents marked confidential, 92 marked as secret, and 25 documents marked as top secret. There's also a reference to some of the various compartments. You know, we've seen before the idea that there were documents that were labeled TSSCI, which is sensitive compartmented information. This is stuff that you've got to have special clearance to be able to see, and it refers to documents that are marked as HCS, which is a reference to human intelligence sources. These are the types of sources that the CIA, for instance, which controls a lot of these types of documents, they are receiving information from human sources. They're spies, essentially, and this stuff is closely guarded by the U.S. government. And the question is, how the heck did this end up in boxes that were being kept in an unsecure environment at Mar-A-Lago? That's the big question. The reference here is to HCS. There's a reference to FISA documents and also documents marked NOFORN, which is no foreign, which basically is stuff that is denied for anybody who is a foreign national. This is, again, these are documents that are so sensitive that there's a tight control over who gets to see them. No foreign nationals are supposed to be able to see them. Again, how did this end up in these boxes of documents that were retrieved from Mar-A-Lago in January?
Truly extraordinary stuff. Evan, continue to stand by for us. You and all of our reporters are pouring through this document, which provides a lot of significant new information about what led to the search of Mar-A-Lago. We're going to come back into the room here with our experts, Carrie Cordero and Elliot Williams. Carrie, I have to say, this they put stuff in this document that is significant, that is new. And what Evan just reported, that there were documents found, to quote the document, a lot of classified documents that contain information about human sources, HCS, FISA, and other documents in Mar-A-Lago. In the same paragraph that Evan was just referring to, they talk about how some of the documents also contain handwritten notes from the president, the former president, then President Trump, former President Trump himself.
Mm-hmm. Well, yeah, so this paragraph 47 contains the information that demonstrates why the FBI had an investigative obligation to go in and make sure that there was no more classified information and remove any additional information that was at Mar-A-Lago. And this included the 15 boxes they reviewed that had been there, included 25 documents marked as top secret, 92 documents marked as secret. Just to give our viewers a sense, when I used to work at the Justice Department, the National Security Division, and handled documents that are at the secret level or at the top secret level, we work in what's called a SCIF, which is like a secure vault, a secure room that certain people only who have clearance have access to. Then within those rooms, we keep these kinds of documents in locked safes. And every night before you go home from work, you have to handle the documents, put them in the safe, lock the safe. The entire room becomes secure. There are huge amounts of procedures and protocols that are involved in keeping these kinds of documents from inadvertent exposure. And what this document lays out is that the FBI agent who testified to this document said that he had no information indicating that Mar-A-Lago had been approved as a secure facility. And so these documents were not authorized to be there. And so they had an obligation to make sure that national defense information was protected.
Not only was Mar-A-Lago not authorized, but the document also says that I do not believe any spaces within the premises have been authorized for storage, and that there were not individuals authorized to be handling this material. Stand by for just a moment, Elliot. I want to go to Steve Hall. He's the former CIA Moscow station chief. Steve, a lot of information here about the concerns, the heightened level of concern about the types of documents that were being stored at the former president's home. What do you make of what has been revealed so far?
Yeah, I mean, the first thing that struck me as I was trying to go through this, like everybody else is the use of the HCS secret classification. That's human information. That's basically information from human spies. So the TSSCI stuff is usually technical types of capabilities that the U.S. government have, which is bad enough because if the technical information gets out there, then of course our adversaries outside the United States will have a better idea as to how we collect that technically. But the HCS stuff basically means that there's information in those boxes in the basement of Mar-A-Lago that pertain to or possibly came from human sources, human spies. And while it's bad to have a technical capability dry up on you, in the case of human sources, they usually get imprisoned, and if it's in a place like Russia or any other authoritarian society, they're oftentimes simply executed. That type of information is just incredibly sensitive. As a former CIA guy, it sends chills up and down my spine when I hear that there's HCS information in somebody's basement and not secured as it properly should. It's just, it's really, really bad.
Yeah, it's a really extraordinary thing. There's also information in this affidavit that indicates that the Trump team was making a lot of very broad claims about why they should not return these documents to the government.
Yeah, that's always been a big question for me. I mean, it's been, you know, there's a lot of law stuff. There's a lot of legal questions that are going around, and quite rightfully so. I will certainly defer to CNN's legal analysts on that. But for me, the big thing that's missing is, you know, what is the innocent narrative here? In other words, what is a good explanation for why really anybody, but certainly a former president included in that group, would want this stuff or have this stuff, you know, stored in the basement? I can't come up with a good answer. If the answer is, well, he just, you know, missed it and people were throwing stuff in boxes, That doesn't seem to be a very professional way to go about it. Certainly not a good way to protect classified information. And if the answer is something darker, like I want to hold it in reserve or I want to bargain with it, I mean, that's horrible too. We just don't know. But the bottom line for me is I can't think of a good reason that everybody says, yeah, okay, I understand why the former president would take this incredibly classified information home with him.
We are all just asking that question. Steve Hall, just stand by for us. Let's bring in CNN's Pam Brown. Pam, there is a lot in this affidavit that really shows how extraordinary and unusual this case is, including that the FBI actually waited to look inside these boxes. They spent a lot of time going back and forth with the Trump team on this. What do you know?
They did. And as someone who's covered the Justice Department for many years, what stands out to me is that gap in time. It was the criminal referral in February, it says, that launched this investigation from the FBI. But it wasn't until 3 months later, in May, that the FBI did a preliminary review, according to page 17 of this redacted affidavit. And what it seems like from reading through this is that is when this investigation really escalated, because when they looked through these 15 boxes, 14 of the 15, it says, had classified information, some with some of the highest classification marks. So that clearly raised the alarm bells for the FBI. It then went to visit Mar-A-Lago in June, and then of course the search warrant was executed not long after that over the summer. But it also shows just how unusual this case is, right? I mean, the fact that it waited 3 months, it shows an extraordinary amount of deference for the former president. In a typical case, Abby, if the FBI were to get a referral like this from National Archives or someone else, that there's all this classified information intermingled with newspaper clippings and personal records with these high classification marks, the FBI would want to go right in, take a look at this material, launch this investigation right away. Instead, it took 3 months for it to start that preliminary review after opening the investigation that then led to concern about 3 statutes potentially being violated, including the Espionage Act, a concern about national security. So it's interesting to note just the level from the level of deference initially to the level of alarm that it escalated to once they saw what was in these boxes.
Yeah, it's a really good and important point, Pam, because the argument that's being made by the former president and his allies is that this is all political, that he is being targeted, and yet the facts and the timeline show that they were given a lot of time, that they were given a lot of communication, and yet the documents were not returned. Pam, stand by for us. CNN's Caitlin Collins is back with us now. Caitlin, there is an interesting and notable letter at the end of this document. What is in this letter?
Yeah, for people who are reading at home, it's in Exhibit 1, and it's a letter from Trump's attorney, Evan Corcoran, who is still representing him right now, to Jay Bratt. Jay Bratt is the lead Justice Department official on this case. He was there, present the day of this search. He was the one who actually contacted Trump's attorney and asked them to, they announced that they were there, asked them to turn the cameras off, and then asked, which attorneys were there on the ground to greet them. So on May 25th, Jay Bratt gets a letter from Evan Corcoran. That is about a week before Jay Bratt and 3 other investigators actually went down to Mar-A-Lago. That is when they surveyed this room, this storage room, where a lot of these documents were being kept, apparently in a haphazard manner, according to what we can see in this affidavit. And in this letter from Evan Corcoran to the top Justice Department official on this, he basically is going through the reasons for defending why Trump had these records at Mar-a-Lago and why he had not turned some of them over. And he makes a few points. One is that they claim that the president has the absolute authority to declassify documents. That's a claim that you've seen Trump's allies making in recent days, though experts have said that that's not how it works. You actually have to go through a process. He says that presidential actions involving classified documents are not subject to criminal sanction. He says that the Justice Department must be insulated from political influence, arguing basically they couldn't do that if Trump is, running for re-election. And then it says DOJ must be candid with judges and present exculpatory evidence. This is the part that stands out, where Evan Corcoran, this Trump attorney, is making this argument in a letter about a week before investigators visited Mar-a-Lago, where he says that pursuant to a policy where the DOJ must present exculpatory evidence to a grand jury, we request that the DOJ provide this letter to any grand jury considering evidence in connection with this matter, or any grand jury asked to issue a subpoena for testimony or documents in connection with this matter. That is a letter that was sent from Trump's attorneys to the Justice Department officials on this case about a week before those very same Justice Department officials went to Mar-A-Lago to see where these documents are being stored. I want to note one other thing is Evan was talking about what they found down there at Mar-A-Lago in the initial 15 boxes that were sent to the National Archives, Abby. They talked about how they were being kept. And basically they say that of the most significant concern was that highly classified records were unfolded, intermixed with other records, and otherwise improperly identified. Basically arguing that a lot of them were not in the proper condition or storage and mixed up with other documents, they say.
That's right. It's a lot of it. A lot of this is about the carelessness, it seems, that the Trump and his team had with some of these incredibly sensitive documents. Stand by, Caitlin. CNN's Caitlin Polance is now with us. Caitlin, the FBI in this affidavit says the classified materials were brought to what they called an unauthorized location, presumptively within Mar-A-Lago. What can you tell us about that?
Well, Abby, when you look at this affidavit, there's essentially two parts of this investigation. The first part is those boxes that they got back, that the National Archives got back in January and were quite alarmed by because there were classified records in them. And then there's the second part. The second part is about the belief that there were still classified documents, national defense information, presidential records that shouldn't be at Mar-A-Lago, that were still there even after that January return of records. And so that's the part that I want to focus on. On these 38 pages, there is a significant amount here in a section called "There is probable cause to believe that documents containing classified national defense information and presidential records remain at the premises." The Justice Department is explaining why they need to go in there to do that search, to get back records that are unsecured. And one of the main points they make is that Mar-A-Lago, after the presidency, at least beginning on January 20th, that there was no secure location there authorized to hold classified documents. And they make that quite clear in this. They're saying that places like the residential hall, suite, the Pine Hall, the 45 office, so the office of Donald Trump, and other spaces are not places that you could keep highly sensitive federal records after the presidency. And that is the reason why they needed to go back in there. And that is what they outlined to the judge. Unfortunately, there are several pages here that are pretty redacted as to why they believed that there were still items there they needed to go and get. But they do outline that they needed to go back and search many of the spaces that Donald Trump would have been in after January up until August this year.
Thanks, Caitlin, for that. Evan Perez is still with us. Evan, so the affidavit says clearly that federal investigators believe that they could uncover evidence of obstruction at Mar-A-Lago. That is evidence that might hamper their investigation.
Right. It makes reference to that. Unfortunately, a lot of that part of the document appears to be redacted, and really, you know, you get this. I think we need to step back first and point out that this document would have been the one that they gave to the judge to authorize the search, right? So this is kind of a bit of a dated document. We don't know what else they found, what other indications they found, but there's something that prompted them to believe that even after they went there in June and took away some classified information, they believed that there was something imminent that could harm the investigation, something that would obstruct this investigation, and that there were additional documents, which of course, according to the receipt that they provided that day, tells us that they did find. One of the interesting things about this is in paragraph 61 of the document, if you go down there to page 22, you know, it talks about the fact that they know that there was classified information, but they cite the law that this investigation, one of the laws that is being used as reason for this investigation, this is the statute 793, the Espionage Act, and the lawyer from the Justice Department, this is presumably Jay Bratt, saying that, you know, it doesn't matter if things are not classified. It just says that information related to the national defense is being stored in these unsecure places. That's the reason why they're going there. Abby?
Evan, thank you so much for that. Really extraordinary reporting. I'm going to bring it back into the room with Carrie here. So much in all of that incredible reporting. But the FBI lays out in this document that one of the reasons they needed to do this was A, the documents, they knew there were classified documents in there, but B, they couldn't be sure that they were stored properly. They were all over the place, intermixed in all kinds of other documents. And they write here that they wanted to identify any persons who may have removed or retained classified information without authorization from the president's residence.
Okay, let's unpack when we talk about what a top secret document is. That is a document that, if released, could cause exceptionally grave damage to national security. There were 25 of those documents that either could have been mixed in with others or by themselves. There simply is no reason why those ever had a place outside of the kind of facility that Carrie was talking about a little bit earlier, which is secured, maintained by a custodian, locked, and so on. There were 92 documents, and this is back from paragraph 47, which Evan was talking about a moment ago. 47 documents identified as secret. Secret documents could cause serious harm to the national security if they were publicly disclosed. These are not accidental mishandling of documents. There had to have been some intent here, because based on how, in order to get them out of the White House and into an unsecure location. I think it's just, there's a lot of government terms of art in here, and it's just really important to step back and really pay attention to what we're talking about when we talk about the kinds of things.
A lot of government terms of art, but I have to say, Carrie, you don't have to be someone involved in the government to understand that classified documents should not be stored willy-nilly in someone's home, even in the home of a former president. But this extraordinary letter that Caitlin reported on from Evan Corcoran with an attorney for the former president seems to suggest that he cannot be held accountable as a former president for the mishandling of classified documents. What did you make of that?
Yeah, so I want to address this issue of declassification, because there is an argument that appears to be being made, perhaps by the former president, that he had, or we've heard this in the public commentary a little bit from his former aides, that he had declassified documents. So a president does have the authority to declassify documents. And it's not so much an issue that there is a really defined required process, because this is an executive authority of a president to be able to declassify. So even if a former president didn't follow a particular process, there still needs to be some demonstration that it actually occurred. And that is what is missing. It's missing from that letter that is attached as an exhibit to this document. It is missing in any argument that is being made on behalf of the former president. And I would note, the FBI would have had an obligation to tell the judge if they had evidence that a declassification had actually occurred, because they would have had an obligation to provide what's known as exculpatory information. So if the government had any indication that the former president had actually declassified this information, it most likely would have been in this document, and it doesn't appear to be based on what we know.
Real quick, think about other powers the president has. If the president were to send troops somewhere, he could think it, but he has to convey that order to somebody. It has to be documented somewhere. There has to be a process behind it. He might have wanted these documents declassified, but if there was no process backing it up, they're not declassified.
Right. As far as we know, there has been nothing revealed publicly that indicates, and there's nothing in this document that has been released in part that indicates there was an actual declassification.
Elliot Williams, Carrie Cordero, thanks for staying with us, and thank you for joining Inside Politics. Stay with CNN. Bianna Golendriga will continue our coverage of this extraordinary breaking news after a quick break.